So immediately after the Supreme Court's recent decision in New York State Rifle and Pistol Association v. Bruen, California went ahead and passed a number of new gun control laws, including 2 new laws that allow private individuals to sue gun manufacturers and gun stores for civil liability. So let's talk about this. But real quick before we jump into this video, if you think the state of California needs to stop defying the Supreme Court's recent ruling, go ahead and hit that like button and subscribe. I also want to mention that if you're interested, you can now purchase channel merch. You can purchase a shirt like this one, and then we have 2 other designs as well. One of the shirts is in 2 different colors. So I will leave a link down below. That's a great way to support the channel. And if you do end up purchasing a shirt and you receive it, go ahead over to my Instagram, tag me with you and your shirt on Instagram. And again, I just like to see everybody who purchased the shirt, who's supporting the channel, and I really like engaging with you. And that's another great way to do that is over on Instagram. So I guess in the intro, in reaction to the Supreme Court's recent ruling in New York State Rifle and Pistol Association v. Bruen, the state of California passed a slew of new gun control bills, which included 2 laws that will allow third-party private individuals to sue gun manufacturers and gun stores for civil liability. The bills that were signed into law are AB 2571 and AB 1594. These bills, which were introduced in the state of California, seek to create a backdoor civil lawsuit mechanism where people can sue gun manufacturers and gun stores under state laws, despite the federal protection gun makers and gun manufacturers and gun stores have under the PLCAA. Now, if you aren't aware, the Protection of Lawful Commerce in Arms Act, or the PLCAA, is a U.S. law that protects firearms manufacturers and dealers from being held liable when crimes have been committed with their products. But one important thing to keep in mind, though, is that these companies and dealers can still be held liable for damages resulting from defective products, breach of contract, or their own criminal misconduct. This federal law, however, has protected gun manufacturers and industry members from being held liable for conduct that they had no part in. However, one new strategy of anti-gun individuals and states like the state of California is to move towards bringing these state-level civil lawsuits against gun manufacturers based on things like negligence in marketing or negligence in sales. And that is exactly what is now happening in the state of California with these 2 new bills. So the first bill we're going to be talking about is Assembly Bill 2571, and it was introduced by Assembly Member Rebecca Bauer. This bill bans advertising or marketing firearms or ammunition in a way that is so-called attractive to minors, and that replaces the language in current law which bans specifically advertising to minors. This legislation is broadly worded so that almost any marketing can be argued as attractive to minors and therefore actionable for a civil lawsuit. The bill AB 2571 states, this bill would prohibit a firearms industry member, as defined, from advertising or marketing any firearm-related product as defined in a manner that is designed, intended, or reasonably appears to be attractive to minors. The bill would impose a civil penalty of up to $25,000 for each violation of these provisions and would authorize a person harmed by a violation to bring suit to recover any damages suffered. Therefore, the bill establishes a firearms industry member shall not advertise, market, or arrange for placement of an advertising or marketing communication concerning any firearms-related product in a manner that is designed, intended, or reasonably appears to be attractive to minors. So under this bill, anything that is attractive to minors as far as advertising can now be an actionable civil lawsuit by one individual who is claimed to be harmed by that. They can then sue the gun manufacturer, and that is $25,000 per each time that marketing or advertising went out. Now, what are the standards established for when a company or manufacturer is marketing something that is attractive to a minor? Well, the bill states, in determining whether marketing or advertising a firearms-related product is attractive to minors, a court shall consider the totality of these circumstances, including but not limited to whether the marketing or advertising A uses characters that reasonably appear to be minors or cartoon characters to promote firearms-related products, B offers brand name merchandise for minors, including but not limited to hats, t-shirts, or other clothing, toys, games, or stuffed animals that promotes a firearm industry member or firearms-related product. C offers firearms-related products in sizes, colors, or designs that are specifically designed to be used by or appeal to minors. D is part of a marketing or advertising campaign designed with the intent to appeal to minors. E uses images or depictions of minors in advertising and marketing materials to depict the use of firearms-related products. F is placed in a publication created for the purpose of reaching an audience that is predominantly composed of minors and not intended for more general audiences composed of adults. So the bill establishes some standards for when it is marketing to a minor or when something is attractive to a minor as far as marketing, but really the discretion is left up to a judge to look at the totality of the circumstances, and then the judge, often a left-leaning judge in the state of California, gets to determine if there was a violation by the gun manufacturer or the gun dealer or the firearms industry member. So as you can see, this bill really has a lot of vague catch-all phrases and ideas, which really leads to the ultimate goal of dragging more firearms manufacturers into courts under this whole advertising language. Again, this is all being done despite the PLCAA's express protections of gun manufacturers and dealers. And even more concerning is that this bill, AB 2571, was passed with an urgency clause, meaning that it went into effect immediately. So this whole manufacturing advertising issue is already of a concern to a lot of manufacturers and gun dealers because this went into a law immediately. But the state of California did not just stop at targeting advertising. They also passed AB 1594, also known as the Firearms Industry Responsibility Act. This bill creates a private right of action against firearms industry members for failure to implement reasonable controls. And that is a term you're going to see pop up quite a bit in this bill, this vague term of reasonable controls. This intentionally vague term of reasonable controls subjects the firearms industry to crippling lawsuits regardless of whether there's any actual violation of law on the part of a manufacturer or gun dealer. Instead, a criminal third party's conduct can now serve as a basis to sue the manufacturer or dealer because they did not engage in reasonable controls. Now, under this bill, reasonable controls means reasonable procedures, acts, or practices that are designed, implemented, and enforced to do the following. 1. Prevent the sale or distribution of a firearms-related product to a straw purchaser, a firearms trafficker, a person prohibited from possessing a firearms under state or federal law, or, and here's a really interesting part that they slid into this bill, a person who the firearms industry member has reasonable cause to believe is at substantial risk of using a firearms-related product to harm themselves or another, or of possessing or using the firearms-related product unlawfully. So that part is interesting because now under this bill, a gun store, manufacturer, or a firearms industry member can now subjectively decide to not sell a firearm or product to someone, even if that person is not a prohibited person, maybe passes a background check. Some reason this bill says that no, we're going to include this subjective standard to where if you pass a background check, maybe a gun store can then profile against you still and decide, no, we're not going to sell you a firearm. And under this bill, if someone believes that an industry member has failed to meet those reasonable controls or that vague term of reasonable controls, well, then under the bill, a person who has suffered harm in California because of firearms industry member's conduct may bring an action in court of competent jurisdiction. So under this bill, any third-party person who claims to have suffered some harm from a criminal who used a gun that was sold to them can then sue a dealer or manufacturer claiming a failure of that dealer or manufacturer to meet those so-called reasonable controls. So this is how the state of California is responding to the Supreme Court's recent ruling in Bruen. No doubt these laws will be challenged in court because of the violations of the PLCAA, First Amendment concerns as well, because of the whole free speech violations of advertising and marketing, and also the whole right to keep and bear arms issues that's clearly at play here as well. Now, in fact, CRPA and GOC have already filed a lawsuit challenging AB 2571. So I always recommend you guys go support organizations that are actually putting in the work. GOC and CRPA are great state organizations who really do engage in a lot of these lawsuits on our behalf, and they are challenging one of these bills that was passed, that one being AB 2571. So that's what the state of California is currently doing. I will definitely keep you guys updated if anything else develops. If you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this is built by Arm Scholars, and this nation will be maintained by Arm Scholars.